Welcome, everyone. This is the fifth lecture of the module Institutions of the European Union. My name is Maarten van Munster. I'm one of the two lecturers together with Rick-Jan Brinkman. So I know more or less half of you, I think a bit less. And for the other half, I am new. We decided to split the last two lectures, so lecture 5 and 6 between us. And I do this lecture in the form of an audio lecture, and Rick-Jan Brinkman does next week, lecture 6. Today we're going to talk about the Court of Justice of the European Union. That's the first part, and that's of course one of the institutions of the EU. The other institutions that we have discussed in previous weeks, I hope you still remember, were the European Commission, the Council, so Council of Ministers or European Council, and the European Parliament. Now, the Court of Justice is, of course, the judicial branch of the European Union. We're also going to talk about decision-making procedures, and that's a bit tough and maybe a little bit dry, but I will try to make it as interesting as possible. So these are the contents for today. We're going to first talk briefly about how the Court of Justice of the European Union evolved, so a bit of history, very brief. Then we look at the structure of the court, how is it organized. Then we look at the powers, what can it actually do. And finally, we make the move to the decision-making procedure. So where do the laws come from in the European Union? What are the legal instruments of the European Union? Now, we like to start with a short introduction that has to do with an institution that is in the news, and that is for the court maybe not so easy as for some of the other institutions, but I think we can refer to this case, the Google case. As you may know, big tech companies are increasingly in trouble with the European Union, and in my lectures I already referred to cases that have been started by the European Commission against Microsoft, for example, or Apple, but also Google. And when the Commission starts a case against such a big tech company and it imposes a fine for violating usually anti-competition rules or violating competition rules, then these companies tend to go to court and they try to have these decisions annulled. Now, Google has been fined 2.4 billion euros for favoring their own companies in their own search results. And this is, of course, a problem. You can't do that. Google is so powerful on the internet that some people sometimes even tend to forget it is a private company. It is sometimes seen as the gateway to the internet, at least in many Western European countries. So, the EU has strict competition rules that companies have to adhere to, and if they don't, they can get fined by the European Commission. This has happened, and after that they usually go to court. Often the General Court first, and then they can appeal at the Court of Justice, but I will explain that later. So this is clearly an old historical picture from the Court of Justice a long time ago. And we have many more judges today, and also, fortunately, or maybe not fortunately, pictures in color. CJEU stands for Court of Justice of the European Union. That's what the abbreviation stands for. So the Court of Justice started in 1952, when it was part of the European Coal and Steel Community. An important development was in 1980, in the 80s rather, when the Court of First Instance was created. And that is now called, as you can see in the fourth bullet point, the General Court. The General Court was created to deal with the enormous workload of the Court of Justice. It is logical with the growth of the European Union that many more cases came to the Court of Justice and needed to be adjudicated. So the General Court was helping with that. So more and more judges over time. The institution has clearly grown over time. And we see a picture here of the court, which is located in Luxembourg. These are the two golden towers. The court seems to be made out of gold. Now, there are hundreds, if not thousands, of interesting cases that we could talk about, but we will only talk about one case here that the court has dealt with. And why this case? Because it is so important and so illustrative of the role of the Court of Justice for the European Union. And it is the case of Cassis de Dijon. Now, what was Cassis de Dijon about? As you can see in this slide, Cassis de Dijon is a drink, an alcoholic drink actually, from France, from Dijon originally, obviously. And this drink was sold in France for a long time, and at a certain moment in time, there was a German importer that also wanted to sell Cassis de Dijon in Germany. But he wasn't allowed to do so by the German authorities. The German authorities said, no, you cannot sell Cassis de Dijon in Germany because German consumers are not used to this kind of drink, this kind of alcoholic drink. They know Brandwein, which is a German alcoholic drink, but Cassis de Dijon is confusing. Its alcohol percentage is lower and it might lead to alcoholism because people might drink too much of it. It can also be confusing, as I said, for consumers, so we need to protect our consumers. That's what the German authorities said. Now, this was a bridge too far for the Court of Justice of the European Union. The court ruled in this case that Germany had to open up its market for Cassis de Dijon. And that was based on the principle of mutual recognition, which states in the second bullet point, the third, sorry, we can see it on the slide, that a product or service that is provided legally, sold legally in one member state should also be allowed to be sold in another member state of the EEC, back then and now the EU. So this principle of mutual recognition and this case of Cassis de Dijon was very important for creating the internal market that we know nowadays with free movement of goods everywhere throughout the EU. And we decided to include this case because it shows so clearly how the court played a very important role in actually structuring, forming the EU as it is today. Now a little bit about the organization, the structure of the court itself, so we have a clearer idea of what the court actually looks like in terms of judges. Well, this is what it looks like. We have the judges, we have the president, the advocates general, and the general court as a layer in the court. If we focus a little bit on the judges, we can say that there are 27 judges for 6-year renewable terms. Officially, it's not required to have one judge per member state, but in practice this is the case. Each member state nominates one judge. The second bullet point says something about the qualifications, or rather the position of the judge. The judge needs to be independent and needs to be impartial too. So the role of these judges is very important. They need to interpret European law, but they cannot follow any dependencies from countries, companies, or any other actor. They must, as it says in the third bullet point, defend the community's common interest. Cases are generally heard in chambers of 3, 5, up to 13 judges, depending on the heaviness, the severity of the case. So the heavier the case, obviously, the more judges get involved. The role of the president is, of course, to preside over the meetings of the court, the internal organization of the court, but also in the courtroom. The president is appointed for a 3-year renewable term, and if you would go online, you can find also a very interesting, if you like law, year book on the court, annual report they call it, and this is also signed off by the president, who explains everything about this court. An interesting role is that of the Advocate General, and this name, Advocate General, can be confusing for some students. For example, the word advocaat in Dutch is very different from what these Advocates Generals actually are. They are independent experts that give opinions to the court before the court makes its final judgment. So they are not lawyers that represent one party in the dispute. No, they actually are working for the court and giving their independent opinions to the judges. However, these opinions are not legally binding, meaning that the court can decide not to follow the opinion of the Advocate General. There are currently 11 of them. Let's focus now a little bit on this second layer in the court. So we have the Court of Justice of the European Union and we have the General Court. Those are the two layers that the courts in Luxembourg exist of. So in the Treaty of Lisbon, the TOL, the CFI as it says, the Court of First Instance was renamed to the General Court. The General Court rules on the, let's say, less complicated cases, dealing often with private parties, for example, individuals or companies. So this example we looked at of Google is a case that would typically end up first at the General Court. If a party is not happy with the result of the judgment of the General Court, there's a possibility to appeal to the Court of Justice. And that is the highest layer of the court. In the General Court we find 54 judges, so that's 2 from each member state. There's also a nice video on the Court of Justice, and I'm not going to click on it now, but you can do it at home. I will also upload the PowerPoints, and then you can watch this video. I do have to say it is a little bit outdated. It's from 2017. So some of the information is not updated to the Brexit situation. So some of the numbers of judges, for example, are incorrect, but you are, of course, smart enough to understand that yourselves. So the third part of this class is about the powers of the Court of Justice of the European Union. What can they actually do? Well, what is very important is basically you can say that the court has the same function that a normal court has in a country. So it needs to interpret the law and it needs to enforce the law. That's what you can see in these two arrows below. Interprets the law, enforces the law, but in this case it's EU law. What is important too is that it's the supreme legal body of the EU and the final court of appeal in all matters relating to European law. So, yes, I think that's rather self-explanatory. It is the highest body of law of judges, and well, their word is the final word on EU law. The second bullet point, it also clarifies the meaning and application of the treaties. So you can compare it a little bit to a constitutional court or a Supreme Court, or the Supreme Court in the United States. There are two categories of types of cases they're dealing with. The first one are the so-called preliminary rulings. Now, and I know this is complex and a lot of new information, but you need to really focus a little bit here, because I'm going to tell you something that you might not know. And this is that most of EU law is actually enforced in national courts. So one more time, most of EU law is actually enforced in national courts. So for example, the Court of The Hague in the Netherlands, or the court in Rotterdam, or the court in Paris, and all these national courts of EU member states, national judges implement and interpret EU law. Now, you can be totally confused now and think, but he just told us about this court in Luxembourg and all that. Now, the role of the Court of Justice in Luxembourg is in these preliminary rulings to help all these national courts that are interpreting EU law if they don't get it, if they don't understand. Yeah? So if a national court needs to interpret EU law but finds it too complex, they can ask the court in Luxembourg for an interpretation. This is called the preliminary ruling. So they temporarily stop the national proceedings, they tell the parties, sorry, we need to stop, we need some more explanation. They send the question to Luxembourg, they get an answer, and then they move on with the case. This is the preliminary ruling. This is very, very, very important. This is basically 70% or more of all the cases are about these preliminary rulings. But next to that, the court has some other tasks, and these are the so-called direct actions. And direct actions are actions that go directly to the court in Luxembourg, so not via a national court or anything like that. And they are usually complaints against member state, for example, or companies like Google that want to fight the fines that were given, those kind of things. Now the four categories that we see, and I will only talk about the first three, otherwise I think there will be too much information here, are the actions for failure to act, the infringement proceedings, the actions for failure to fulfill an obligation by EU bodies, and the actions for annulment of EU legal acts. I'll give one example for each to keep it understandable. So what is an action for failure to act, an infringement proceeding? It means that a member state of the EU, for example, has infringed upon their obligations. So for example, it needs to follow certain EU rules, but it doesn't. And then the European Commission can take this country to court. Let's take a directive. Let's say the Netherlands has to implement a directive. It doesn't implement the directive, then it can be taken to court for infringing upon the treaty. The second action, the action for failure to fulfill an obligation, is when EU bodies don't do what they're supposed to do. For example, they don't legislate where they should have legislated. Or the Commission doesn't act against Google where they should have acted against Google. And this is when the institutions can be taken to court. And finally, there's the action for annulment of EU legal acts. And this is the example of Google that was given a fine of 2.4 billion, but wants to have this fine annulled. It doesn't want to pay, of course. So it goes to court and it says this legal act of this fine that the Commission imposed on me has to be annulled. This is the third action. So quite complex and a lot of information, but bottom line is there are three main direct actions that can go to the court, and the vast majority are the preliminary rulings where the court assists the national courts. After all this information on the Court of Justice and the General Court, we now talk a little bit about decision-making procedures. So this is about how the European Union actually creates laws mainly. So all these laws, all these hundreds, thousands of laws that we are dealing with on a daily basis without being aware of it, where do they come from? How were they made? That is what the topic is for this section of the lecture. Now, there are two main decision-making procedures now, since 2009, since the Treaty of Lisbon exists. And this is the ordinary legislative procedure, and the other category are the special legislative procedures. As the name already indicates, the ordinary legislative procedure is the standard decision-making procedure that the European Union uses. Special legislative procedures are only used in special situations, and on the slide we see two examples. The consent procedure, for example, if a new member state wants to join the EU, the European Parliament has to give its consent. It has to say yes or no. And consultation procedure, for example, in tax cases, the European Parliament is not deciding, but it's only consulted. It's only asked for its opinion. This is also special. I hope you're still with me, because it's quite complex. Now, if you click on this video, you will see how videos are made. And maybe I also, well, let's just click on it and then I can talk a little bit about it later on. I'll stop here because the rest of the video is not that important for you. So let's get back to the slides. Yes, so we looked at the ordinary legislative procedure, and what is important, and this is also a hyperlink, I will not click on it now, but you can do this, as you can see it's a hyperlink yourselves in the original PowerPoints that I will post. What is important is that it shows how the procedure goes. So it starts with a proposal by the European Commission. I also see a typo there, by the way, infographic, I'm sorry, I will change that. It starts with a proposal by the European Commission that sends the proposal to the European Parliament and to the Council. So the Council of Ministers and the European Parliament, and they can make amendments and they can have to try to agree, but they both, and this is important, they both need to be in agreement. They both need to say yes. They both vote for it. Now, this can happen in one go, in one round, and it's called the first reading. They can both say yes. It can also be in a second round, then it's called a second reading adoption, or in a conciliation, a third round. Now, if you click on this link, you can find very neatly, very nicely shown how this process goes. But the bottom line for us is that in the ordinary legislative procedure, the European Commission proposes the laws and the Council and the Parliament together adopt the laws. Now, remember, in the special legislative procedure, this is different. Here, the European Parliament, in the special procedure, it doesn't make amendments, for example. It only gives its consent, or it is only consulted and it cannot decide. So that role of the European Parliament is different in the special legislative procedures. In the ordinary procedure, the Parliament decides. So what are these legal instruments that we're talking about? What is the European Union actually producing when it comes to law? If we look at the legislative instruments, the most important ones are on this slide. And those are the regulations, the directives, and the decisions. So the difference between a regulation, a directive, and a decision is not so difficult. It's basically this. First of all, a decision is not aimed at the general populations of a member state, but it's only applicable to specific individuals. For example, if the Commission finds Google, this is a decision, because it's one act aimed at one specific company, namely Google. Regulations and directives, however, they are addressing member states, usually all member states, but sometimes also specific member states. So the category of addressed individuals is much more general. This is the difference between decisions, regulations, and directives. Now, if we distinguish the regulation from the directive, there's also an important difference. And that is that a directive needs to be transposed into national laws. So directives need to be transposed into national laws. So they give general outcomes that all the member states have to achieve, but how the member states will achieve that is left up to them. They can make their own national laws in which they transpose this directive. A regulation does not require transposition. A regulation is directly applicable, so no national laws have to be made. There are some examples on the slides. I will not talk about them. I don't want to make it too confusing. And as I said, I want to limit the information a little bit to get to the core of what is important. But if you ask me what is important for us to know for the exam, is that you know how a regulation is different from a directive. And the difference is a regulation does not need to be transposed into national law, and a directive does need to be transposed into a national law. So directives always have deadlines. The deadline is for the member state to adopt the national laws. And again, the difference there is that the decision is aimed at a specific person, usually a legal person. It can also be a natural person or a member state. I hope this is clear. There are many examples you can find of regulations and directives. We already talked about some of them in previous weeks. There are, for example, many directives on the environment. And we have, for example, a regulation here, the Novel Foods Regulation as an example, but you can find many more. For example, the Data Protection Regulation, to just mention one example that has been very much in the news. There are also some other acts that the European Union can create, and they are a bit less important, I think, because they are not binding, not legally binding. That means that they don't have to be followed and they cannot be enforced in a court. Yes? So regulations, directives, decisions, they are binding. So you can actually go to a court and say, point to the regulation and say, this and that should have been done, it hasn't been done, so now the court has to enforce it. That's what it means. Now, recommendations and opinions are not binding. In that sense, less important, maybe less interesting, but we do have to mention them because they also exist. Yeah. So, by the way, avis is the French word for the opinion, and we see that in the little box on the right. Good example of an opinion is, for example, in certain procedures, or let's take the ordinary legislative procedure, we just talked about it. There, the Committee of the Regions, which is a committee that has to represent specific interests of the regions of Europe, can give its opinion. It is asked for its opinion. What do you think of this piece of legislation? But its opinion does not have to be followed. Now, as I said, this lecture was a bit, maybe a bit dry and a lot of information. So I think it's very important we have the summary at the end and we go through the important conclusions. Okay? So we first talked about the Court of Justice of the European Union. This is the judicial body of the European Union. So the judicial branch. If you think of what you've learned in the political dimension of Europe, that we have the legislative and the executive and the judicial branch. Think of Montesquieu. Then at the European level, the Court of Justice of the European Union is this judicial branch. That's separation of powers, of course. You can compare its role to that of a constitutional court. It's the highest court when it comes to the EU, and it makes many important decisions, and it has formed a lot of what we know nowadays as the EU. That's why we discuss it separately in this lecture. The rulings of the Court of Justice are final, and they are actually of a higher nature than national law. You could say they have a supranational nature. Remember, we talked about this before. Although, well, let me not go into that. Sorry. Mutual recognition is the principle that we discussed when we talked about Cassis de Dijon. And there we could clearly see that the court had a very important role in creating this internal market in Europe. Because of the ruling of the court, the products, in this case Cassis de Dijon, had to be accepted also on the German market. And there also had to be recognition in France of German products, of course. Yeah, so this principle of mutual recognition made it possible to harmonize the EU's internal market rules. That was about the courts, and then we talked a little bit about the decision making. Where do all the rules, where do all the laws in Europe come from? We said there are two important procedures, the ordinary legislative procedure and the special legislative procedure. Now, 90% of the time, the ordinary legislative procedure is used, and that's also why it's called ordinary. What it means is that the Commission proposes a law, and the Council and the Parliament adopt the law, decide together. In the Council, qualified majority voting is used, and in the Parliament, a simple majority or an absolute majority is used. What else can we say? Well, the institutional triangle, you know, one more time, the Commission, the Parliament, and the Council. We show this every week. They play this key role in the decision making. So you can also think back at this picture we show every week of the institutional triangle for the decision making. And finally, we said a few words on binding legislation, directives, regulations and decisions, and non-binding ones, recommendations and opinions, and we said they were less important. It says on the slide they are based on primary legislation. That is correct. all these directives, regulations, and decisions in the end are all based on the treaties. So the Treaty of Lisbon has the TFEU and the TEU, as they are called, and they can be used to legislate. Now, this was a lot of information, and I really strongly recommend that you do the reading and you maybe listen or watch this video, or it's not really a video, yeah, sort of video, a couple of times so you truly understand everything. And if anything is still unclear, then you let us know. Please send us an email or contact us in a different way so we can further elaborate on things that you still find difficult. Let me see if I have another slide. Yes, this is the last slide. Next week we have the other bodies and the specialized agencies. That will also be a video lecture because of we still cannot organize our physical lectures. There will be a brief exam review, some tips on how to study for the exam, and we would also like to hear your feedback. This is also important for us to hear from you what you thought of the course, how we can improve the course, what you liked and what you didn't like. And you can always meanwhile send me some questions and suggestions, and that's the same for Rick-Jan Brinkman, whose email address is not here, but if he is your lecturer you will know that. Alright, thank you very much for your attention, and I maybe see you again soon in class or at school. Bye bye.